Hi there, thanks for joining us. My name is Beth Hale. I'm a partner at CM Murray and our General Counsel, and I'm joined today by our regulatory partner, Andrew Pavlovic. We're going to be talking about NDAs. The reason we're talking about NDAs right now is because the SRA have just published a thematic review into law firms' uses of NDAs and how they are drafted and prepared and the approach that firms take to them. It's worth, I think, giving some background to why NDAs have come into the sort of public consciousness in quite such a dramatic way as they have over the last few years. And looking back and preparing for this 10-minute talk, I noted that our CMR's first ever 10-minute talk was in fact on the topic of NDAs in December 2021. So I feel like in a way we've come full circle, but it's also just really important that these issues remain front and centre of everybody's minds, and there's a good reason for that. And in the wake of the Me Too movement in 2017, 2018, there was a spotlight very rightly shone on how victims of sexual misconduct in the workplace and elsewhere were gagged essentially by being asked to sign very onerous confidentiality provisions. And there has been an ongoing campaign by a number of people, but most notably and most recently, Zelda Perkins and Julia McFarlane, who run the Can't Buy My Silence campaign, around misuse of NDAs. And obviously the regulator, the SRA, has taken particular interest in this. In March 2018, they issued a warning notice on the drafting of confidentiality agreements, and they have paid attention to that ever since. And they have recently, as I say, just this week, published a thematic review on that issue. So, Andrew, just briefly, what methodology did they use, the SRA, for this thematic review, and what are the key findings that they've made?
So they did a number of things. They surveyed around 150 firms, mostly firms that deal with settlement agreements on a regular basis, such as employment firms. They then visited 25 firms of varying size, conducted interviews with fee earners, and reviewed NDAs that the firms had either drafted on behalf of clients or had used to resolve their own internal matters. And they also looked at internal investigations into misconduct carried out by firms, again, to see the approach that was taken to those, whether incidents were self-reported, and again, whether NDAs were used to resolve them. In terms of the key findings, they didn't find any evidence of firms deliberately trying to suppress or the reporting of information, but they did identify some trends or practices which inadvertently might have that result. And the three that I thought we could focus on for the purposes of today's talk are: one, the use of templates; secondly, training or a lack of training; and then thirdly, economic and commercial pressures. So starting with templates, 84% of the firms said that they used template agreements and template clauses, which I can see makes sense in terms of consistency. But interestingly, only a quarter of firms said that they'd ever stopped a client and questioned them as to whether an NDA was appropriate at all for the matter that they were instructed in. So maybe if I can turn the tables on you, Beth, and ask you, what are the risks of using templates, and how can those risks be mitigated?
So I think, as you rightly say, it's totally appropriate for firms to have template NDAs in their precedent settlement agreements, for example. It avoids the risk of things being missed. It avoids the risk of getting it wrong. So long as you keep them up to date and they are clear and everyone knows where they are and what they are and understands what they're for, I think that's it's totally appropriate. I think the risks of using them are that they get out of date, or that people use them, as you rightly say, without thinking about it, and they just use them as a knee-jerk. And here's the template, here's our precedent, it includes an NDA, and no one ever thinks about it, and no one looks at whether it applies or is relevant for the particular circumstances. So I think the risks can be mitigated in a number of ways. One, through training of staff, training of lawyers within the firms who are using those precedents. Two, through good precedents, frankly, with sort of notes in which say, you won't always need this clause. Apply your mind when you're using this template as to whether you actually need this clause. Is this bit relevant? So good precedents with kind of questions to make people think as they work through them is another really key thing. And 3, just having someone who is making sure that the templates are being regularly updated, who is monitoring the regulatory landscape and the best practice and the legal landscape to know that they are up to date and current and represent current best practice.
That's all good, very good advice. There was another issue raised, which was that precedents were used, and they might have the carve-outs and have a very good clause there, but then there are other clauses, such as clawback clauses or non-derogatory clauses, which might create a degree of confusion to a lay person as to the extent to which those cut across the carve-outs. So what are the risks there?
Well, I think this is another issue around sort of quality of precedents and clarity of understanding of the people using those precedents, and just making sure that you're not dragging one clause from one document and another clause from somewhere else and kind of just bundling them together. So just for the main message about NDAs in the warning notice. I mean, the warning notice is detailed. I don't propose to go into it in all of its detail today, but the sort of key message I think people ought to be taking away from it is around clarity of drafting and clarity of advice to those signing NDAs. So an NDA should be really, really clear about what is and is not permitted, and the people who are signing the NDA should be really clear about what they are signing up to and what they can and can't do having signed up to it. And I think the issue that the SRA have identified is that sometimes you have a beautifully drafted NDA with all the carve-outs in it that say you can talk to obviously lawyers, you can talk to medical professionals, you can talk to therapists, you can talk to the regulator, you can talk to the police, you can talk to your spouse. They have these beautifully drafted NDAs, but then they have separately a clause saying you must never make any derogatory comments about your employer, and those carve-outs don't apply to that non-derogatory comments clause. Well, that clearly they cut across one another, and so I think if your provisions are well drafted, then those carve-outs should apply to not just the NDA, but also to the non-derogatory comments clause and to any clawback provisions. If you determine that a clawback provision is appropriate at all, and it is appropriate to have it triggered by breach of a confidentiality agreement, you need to make sure that that is subject to all the carve-outs. So a precedent has to be kind of tied all together, and not just kind of different clauses gathered from various different places.
And you mentioned training earlier. I mean, 64% of the fee earners survey said they were aware of the warning notice, although people had sort of differing degrees of understanding of it. Only 12% of firms said they provided NDA-specific training, and there was also a concern identified that firms didn't do much training for fee earners in terms of dealing with vulnerable individuals, and people are often in a vulnerable state when they're being asked to sign these sorts of agreements. So what role can training play, and do you think there is a role for NDA-specific training for firms?
I mean, the short answer to that is yes, absolutely. And I think I was surprised, I have to say, by the statistics on awareness of the warning notice, awareness just more broadly of issues around NDAs and ethical and regulatory issues around the drafting of NDAs. I think firms who are regularly drafting settlement agreements or who are advising on them, either advising employers or employees, ought to make sure that all the fee earners who are doing that kind of work know what the rules are, know what the warning notice says, have read the warning notice and understand what their obligations are. I think it comes back to perhaps not for today, but a broader topic around training on some of these regulatory issues that I think is often lacking, actually, that people are trained on their technical expertise, which is obviously absolutely vital, but less thought goes into the training on the regulatory obligations.
I would agree with that, and that's obviously.
I mean, you would obviously agree with it. You're a regulatory lawyer, but I think
the LSB looking at the issue of continuing competence and what the various regulators are doing to ensure that, and with a particular focus on regulatory issues and ethics and professionalism. So that's something that I'm sure we'll be hearing more from the SRA. But I agree with you. I thought that given how long the warning notice has been around and the prominence of these sorts of issues, I was a bit surprised at the percentages that we saw reported.
Yeah, but especially since I think it's worth saying that there has been a sea change in my experience, in the approach to these kinds of clauses. And it is obviously really positive that the SRA are saying they didn't find examples of deliberate attempts to prevent people from speaking to the regulator, deliberate attempts to prevent people from going to law enforcement. So I think that's really positive, and I think there really has been, since the warning notice was issued and before that, actually, there has been a massive change in the approach to these kinds of clauses by law firms.
Yeah, well, maybe that suggests that firms have updated their precedents, or the clauses are now there, but perhaps people still don't have the requisite knowledge as to why they're there.
Why they're there, yeah. And I think that comes down, doesn't it, to sort of quality precedents and quality of communication within teams.
The final point I wanted to make was this commercial and economic pressure point. So, the point that was made in the review is that the employer is often calling the shots. They quite often impose strict timetables for signing documents. They will only agree to contribute a minimal amount in legal fees. And how can solicitors ensure that they're protecting their clients' interests robustly and properly in those sort of circumstances?
I think this remains a problem, and I think it remains the case that often, where there is a really standard, where there's for example, an employer is carrying out a big redundancy exercise, they are issuing totally sort of standardized settlement agreements saying they're non-negotiable, and offering very small sums in for advice for their employees to go and take legal advice on those documents. And I think, provided that lawyers advising the employees in those circumstances are clear with their clients about the scope of their advice and the limitations of that advice, and that they are talking them through the NDA and ideally recording that advice in writing, although appreciate that may not always be possible, and the SRA recognises that may not always be possible given the limited funds. But I think lawyers advising employees who are signing those kinds of really standardized settlement agreements should not neglect the NDA, should not forget to advise employees on that part of the provisions. Obviously, often the key part of the settlement agreement is the waiver of claims, and that is that has to be advised upon. So yeah, I think the really important thing is that lawyers remember and emphasize to their clients the importance of the confidentiality provisions and give advice on that. And if it's not possible to do that within the legal fees contribution that is being offered, they should go to the employer to ask for further contribution, or ask the individual to pay the extra, although that obviously is likely to be problematic. So the review suggests that an individual lawyer, a fee earner advising on a settlement agreement or an NDA, should speak to their CULP or ring the SRA ethics line if their client is insistent on signing an agreement which contains an NDA which might be in breach of the warning notice or might have inappropriate provisions in it. Are there any circumstances where a lawyer should cease to act for a client in those cases?
This is a difficult one, because obviously if you've advised the client that the clause is in breach of the warning notice, that may be enough to discharge your obligations if ultimately the client decides to go ahead. Equally, I can imagine an example where perhaps an allegation has been made of sexual misconduct or sexual harassment. The firm on the other side has sent across an NDA which attempts to restrict reporting to the regulator or to the police. You're dealing with a vulnerable client who might be in a difficult mental state. And I can see an argument that you might want to say, well, actually, I'm just not prepared to go ahead and let you sign this. I suppose there could be a question as to whether it's enforceable anyway. But I don't know if you really want to go down that route if you feel strongly that they shouldn't be signing. I'd imagine that was a fairly exceptional case.
And presumably the answer is slightly different if you're acting for an employer who wants to include a clause that you would advise them against including.
Yeah, I
If
think
it's the employer insisting on it, presumably there are lots of circumstances in which you'd cease them, and often you would cease to act if that's what they're insisting upon.
Yeah, absolutely. I think if you were telling an employer this, you can't put this clause in, it breaches the warning notice, and they're insisting on it, I think you'd be in a position where you'd have to cease acting, because you can't reconcile your regulatory and obligations with the obligation to act in the best interest of the client. So you'd be in a conflict position there. So yes, it's more straightforward, I think, if you have a disreputable employer client trying to force through an NDA which breaches a warning notice, than a vulnerable individual who perhaps just wants to sign an agreement to bring an end to something. And you're worried that in doing that, they might be restricting their right to complain or to raise that issue in the future.
The review also talks about reminding firms that they have an obligation to report other lawyers where they believe them to be in breach of the regulatory arrangements, whether they think there's been a serious breach of the regulatory arrangements. So if you receive, as a lawyer, you receive from the other side in a dispute agreement which contains an NDA which you consider to be inappropriate or too onerous, what the SRA is saying, you ought to be reporting that to them. Obviously, no one likes to be the snitch, right? No one likes to tell tales out of school, but I think it's really important, isn't it, that we all remember those obligations and remember that we have those obligations. Can you just talk a bit about that, what you should do in those circumstances?
Well, this is a consistent theme that the SRA raised in their thematic reviews. They also raised this in the SLAPS thematic review, where they said that firms were concerned about other sides conducting SLAPs but hadn't reported them. And as you said, the threshold for reporting is where you have reasonable belief that there's been a serious breach of the regulatory arrangements. So I think if you had a clause, perhaps a clawback or a non-derogatory clause or something that was more borderline, and could have the effect of deterring reporting, maybe that wouldn't constitute a serious breach that would have to be reported, and that could be something that you could just push back on in negotiations. On the other hand, if you received, in the context of perhaps a sexual misconduct, a sexual harassment claim, a draft settlement agreement which contained no carve-outs at all, I think you'd be looking then at why that was. And even if the firm responded to say, "Oh, sorry, we sent an incorrect template," that in itself could be, a regulatory issue, because the fact that you spotted it doesn't mean that necessarily everyone else would have.
Yeah, and it's one of the things they talked about, isn't it? One of their case studies was someone having entered into a firm using an out-of-date template where the agreement had been signed and entered into, and no one had sort of flagged the issue. So obviously giving a firm a chance to remove an offending clause would be appropriate, but it doesn't necessarily remove the right to report, I wouldn't have thought, if the breach is serious enough.
Yeah, and that could even be if it's unintentional. If it does raise a concern, because if they're a firm that are dealing with these regularly and sending out wrong templates, then that could be a regulatory issue. We have seen firms fined before for that sort of thing, albeit in a different context. There was a firm fined recently for using a wrong template letter which gave incorrect advice about ground rents. So it can happen.
As I say, I think it's never a comfortable thing to do, and you'd also always want to discuss it with your with your colleagues, and potentially with the SRA ethics helpline before you made that report. But it's really important to remember those obligations, isn't it? So, in terms of your sort of top tips, what do you think firms should be doing now?
Well, I think if this thematic review is representative, then there appears to be a sort of gap in knowledge. In terms of the warning notice and NDA specific training. As I said earlier, the SRA have also identified a concern about lack of training in dealing with vulnerable clients. So I think those are all various training courses which could be pursued. Templates, as you rightly mentioned at the start, making sure that they're up to date. We have our own, of course, check your NDA tool, which is a very useful first point of reference for firms, and it does go through the process in some detail, including that first question as to actually do we need a clause like that at all in our agreement. So I think there is a suggestion here that firms might have to go back to basics somewhat. Yes, there isn't any evidence of any deliberate attempts, but there do seem to be some areas which would cause concern to me about a lack of knowledge and lack of understanding in the area.
I think that's right. I think what really struck me is that the SRA are acknowledging there's been a real change, as I identified earlier, in how NDAs are drafted in this context, and the fact that most NDAs now include the correct kinds of carve-outs and what you'd expect to see. But I think the issue for me is around, do you need an NDA at all? So the drafting has improved immeasurably, obviously not always, but mostly. Firms should really be applying their minds to and advising their clients, discussing with their clients, do you need an NDA? What are you protecting? Why are you protecting it? And is this an appropriate way to protect it? And is everyone clear on what they're signing up to? I think that sort of clarity of drafting and clarity of understanding is so important and remains for me the sort of key point around NDAs.
Agreed.
And I would also echo you, Andrew, that recommend our Check Your NDA tool. It's really useful for sort of working through what you've got and whether it's compliant with the warning notice. Thanks so much, Andrew, and thank you for watching, and see you soon.